The longevity of the Rafale controversy may hinge on the interpretation of just one word. On Friday, the Supreme Court dismissed petitions demanding an independent probe into the purchase of 36 Rafale jets by the Indian government. In para 25 of that judgment, the Supreme Court referred to the pricing of the Rafale deal, in which they said that the government has refused to reveal this price, citing national security. However, the court did say that price details had been shared with the CAG, or the Comptroller and Auditor General, who has placed it before the Public Accounts Committee of Parliament, while a redacted portion of this report has also been placed before Parliament. The Congress denied any of this happened. Now the government has added another twist to the tale by writing to the Supreme Court that what they meant to say was that this is the procedure that is usually followed, and the court has instead understood that this was what actually happened. Now, between this present and past tense explanation could hinge the future course of the legal battle on Rafale. To understand the implications of these submissions in court, I'm joined now by a host of guests. We're speaking today with Alok Prasanna. I also have with me on the phone line Siddharth Luthra. Welcome to both of you, and thank you for speaking with us. Alok Prasanna Kumar, let me start by understanding from you, do you think that this one paragraph and 3 lines in that paragraph of this judgment makes all the difference, as those who had moved the Supreme Court in the first place seems to think so?
To be quite honest, I don't. I do think it's a major error by the court, but we don't know if the error was caused because of what the government said in that note and or what the Supreme Court interpreted that note to be. I think that sort of shows up maybe the court's excessive reliance on that note. But I'm not so sure it will make too much of a difference, because there is no way for the court to say this is the right price for the Rafale or too much has been paid for the Rafale. And it's not something the court will say this is a matter which requires immediate inquiry, because there's nothing to compare it with. I would have understood if there was some material on record to say this is the absolute right price for it, and there is no way anybody else could have paid X or Y or Z amount for the Rafale, and therefore the court could have said there's something suspicious about it. But I'm not so sure, and I'm not a defense expert here, but from what I understand, this is not something that is easily comparable. So even if the pricing details were to be looked at by the court, I'm not so sure what the court would have to say about it.
Siddharth Luthra is also on the phone line with us. Mr. Luthra, on the pricing, the Supreme Court made it clear that they do not have the technical expertise and they do not find it in their jurisdiction to determine whether the price was high or low. But in this one case, there could be a possible misrepresentation or misunderstanding of the facts. Would that make a huge difference, considering it's already well known that a review petition will be in the offing?
Well, I must clarify one thing, that the court kept its hands off pricing, but it appears that one of the factors which the court considered was that the matter was before the PAC. Now, whether it was inaccurately placed by the government, or it's an issue regarding understanding of the court, it is to be determined, because we don't have access to what was given in sealed cover. Really will be based on that, and whether this, if at all, has had a major impact on the court, and whether it constitutes what is called an error apparent in the face of the record. So far as the government is concerned, they have launched what I would call first strike, and before the other side could really consider even filing a review, they've gone ahead and said, look, there seems to be a type of error, please correct it. And having done that, perhaps they have preemptively ensured that any possible review may not, any likely review may not achieve much. But this test of whether it is an error or not will have to be seen based on the available material, and that is how it is to go forth. I mean, I don't think it's an issue of whether the court is competent or not to look at pricing. That's not the point. The issue is whether A, a representation was made to court, or whether B, alternatively, the court misunderstood a fact, and that is a material fact based on which it has based its decision. If the latter is the case, then it's a ground for review. Eventually, whether review is considered or not is a separate issue, whether it's allowed or not. But the issue of consideration is purely this.
Mr. Luthra, the court, when it dismissed the pleas for an independent probe, looked at three factors. One was whether due process was followed, one is the choice of offset partner, and one was, of course, pricing. Now, it is in the part about pricing where there seems to be this miscommunication or misunderstanding or whatever you may call it. Do you think this would impact the overall judgment as well? And have enough of make enough of a difference to what the court finally decided?
I'll put it, there are two ways to look at it, and therefore we can't preempt what the court is going to do. One way to look at it is that the court chose not to go into the pricing because it had, its understanding was that it was before the relevant authority, which is the PSC, and therefore the court did not choose to go into it, and that's why it based its decision on a fact, on a material fact that the matter is before the PSC. Alternatively, it can be argued that because the court was not looking at pricing at all, whether it PSC or not, is not a material fact and therefore not enough of a ground to consider to legitimize a claim for review. So there are both views possible. Again, as I said, they are not really privy to what was given in sealed cover and what the court had before it. And since one is not, it will have to be determined based on what were the available materials and to what extent this aspect of the matter has determined the final outcome of the case. It is possible the court may consider that while this is an error, we will not intervene because it still doesn't change the ultimate course of the decision, or alternatively, the court believes that this is a core and it legitimacy grounds of review.
Another big question which has been raised, and I'll come to you, Alok, is of this business of giving information in a sealed cover. Some people have pointed out that this is the root of where all of this misunderstanding and misinterpretation came. Can you explain to us why this was used, is often used, and is it legitimate in a democracy where you expect transparency on key issues?
So let me give you a little bit from my own experience. I used to practice with Mr. Mohan Parasaran, who was a law officer, and we were involved with quite a few cases where the court did ask us to hand over material in a sealed cover. To me, there are really only two justified reasons to hand over material in a sealed cover, like when the court asked the government to hand over material in a sealed cover. One is interest of privacy. You don't want personal details of privacy and confidentiality. One, you don't want details which I have revealed in confidence to a person to be revealed to the public just because it's a litigation. So, for instance, the service records of something noted in confidence, it may affect how information is given out future. It may make people be less, candid about things. The second is, of course, on matters of security. Now, a lot of times, certain things, actually a surprisingly large number of things in this country require IB clearances, require security clearances from various agencies. Now, these agencies would have spoken to people in confidence. They would have noted their particular observations, and they might have had material which they would not like to reveal to the public at large. So, in some instances, yes, the court would be justified in asking for this. In the present instance, I would still say the court was justified in saying that, yes, please provide us the details in a sealed cover. Now, what were the details which were provided in the sealed cover is the issue here. And I think there is a proper procedure to do this. There should have been some explanation as to these are the broad details that you're providing. Nobody is saying put the details in the affidavit itself. If you're providing something in a sealed cover, please indicate what material you're providing, and any argumentative or any future courses of action, if they're in accordance with the law, should not be in that sealed cover. For instance, something like this, it's not a national secret that the CAG is looking into the matter. I mean, it was reported in the news a few days ago, even before the judgment, that the CAG is looking into the matter. If you have to put something into the sealed cover, it should be something that should not be revealed generally to the public. So I can understand if you're putting in details of armaments, if you're putting in specific details which is governed by the India-France governmental agreement, saying that these are confidential matters will not be revealed to the public. It makes sense. You please put them in a sealed cover because you need to inspire confidence in the other person also that yes, your secrets are generally safe with the government. But unfortunately, I'm not so sure the government has stuck to this narrow view. they have sort of, I mean, if this key fact that whether the CAG is looking at it or not made its way to that quote unquote note in the seal cover, I think that's very unfortunate. I think that is what should be into the
No,
seal
in
cover
fact,
procedure.
let me get Siddharth Luthra in on this. Your view on the whole sealed cover controversy, and also going back to the point about whether the Rafale deal is in front of the CAG or in front of the PAC is a matter which has been widely reported and is in public knowledge. So even if the court would have seen what the government has submitted to them and perhaps misinterpreted it or it was written wrongly, would they have had no way of knowing something which is already in the public domain?
Okay, let me clarify one thing which is important, and I would have a slight variation with what Alok is saying. According to me, there are two reasons, two justifications. I don't think there are any reasons to put material in sealed cover, because putting anything in a sealed cover and tendering to court means that the opposite side does not have the right to look at it, and therefore does not have the right to respond, and the court becomes the sole arbiter of the accuracy of the material, and that can lead to aberrations, considering that you don't have an equal playing ground for all sides to argue. That's one part. The second part is the two reasons when material is put in sealed cover is, one is, as he rightly said, in matters of national security, where what I would call is privileged communications, and that too, it is for the court to determine whether it is privileged or not. The second thing, and most important, most other area where material is put in a sealed cover is during investigative processes. So while an investigation is on, you don't want to disclose it. During the pendency, whatever is filed is tendered to the court in sealed cover. That is part of case diaries, and case diaries are in any case, excuse me, not to be seen even by the accused or by the court other than for liberation. The legal justification for putting this in sealed cover. In this case, it seems that the sealed process was used more because it really seems to be a political slugfight, so that either party does not make it a point, raising exercise or an exercise to make brownie points over their views on a certain transaction, and therefore the court believes that it should be handled with a little sensitivity. Now, having done that, as I don't think Alok or I are aware of what is there in the sealed cover, but there seems to be some gap somewhere. Look, it is right, detailed orders, and this is just because it's an important or sensitive issue it's being banded upon. But errors, typographical and other errors occur. We are all human.
Yeah.
When they occur, the corrective mechanism is A, either you move an application for factual clarification, if it's just a factual clarification. B, you have a right of review, and if that fails, the right of curator. So there are legal mechanisms to be followed. In this case, the government has acted in saying there is error in understanding, so please correct the facts. Now the question is, once this application is there and the review is there, it is then for the court to determine whether it's an error or it's an error apparent on the face of the record, which is the language required for exercise of review jurisdiction, which is really recalling the order and rehearing the matter. So those are the two options now left, and
no, so obviously we don't know where the court process will go, but I'll just round off with Alok. I'll ask you to tell me where you think that the whole Rafale story is going. We know that there are privilege motions now going on in Parliament, and the political fight is on the other end. But have we sort of seen a dead end as far as court proceedings go on Rafale, and it is going to be left to the political arena?
At least at the present moment, yes, because what the court seems to be saying, if you see the full judgment, is we don't think there's enough here to start criminal investigation, because that's really what the relief claimed was. They said, there is enough material here to start the criminal investigation. The court feels it's not there. It's possible that the CAG may find something obnoxious in the deal and may make an observation. It may be placed before the PAC, who may say, yes, this is something completely unacceptable and should not be a thing. Keep in mind that something that the 2G case only really took off after the report from the CAG came out saying this is what we find objectionable about the process. Now, the court is still here feeling its way through it. They're not entirely sure if something has fundamentally gone wrong. And if new facts come to light, obviously the court would say, and if they're sufficient to show that there was some sort of criminality in the process somewhere, yes, they might. But at the moment, on the facts that we know, the court has said, and probably rightly, that look, we can't just simply set up an investigation and say, go find out this, go find out that. There has to be some basis to show that there is like some criminal action. Not to say that the deal is necessarily good. And as I sort of clarified in my piece, there are enough questions that are still answered. It's just that the court may not be the right place to ask for answers of this. And yes, which is why we have a parliament. Yes, which is why we have parliamentary standing committees and so on. And if they do their job, we should be able to get answers. And maybe when the next, if the government changes, we may find out some more answers to this thing. So I think it's by no means an end of any sort, either for the judicial process or in the larger context of the controversy.
All right. So the Rafale controversy at least has got another lease of life, and we'll have to wait and see where this end of the story goes. Thank you so much, Siddharth Luthra and Alok Prasanna Kumar, for speaking with us today.
Thank you.